Do professors at public universities have free speech rights? From An Academic Freedom Exception to Government Control of Employee Speech in the Federalist Society Review, Volume 22, by Nick Cordova, Law Clerk for the U.S. Court of Appeals for the Third Circuit. If a professor at a public university says something controversial, does the First Amendment protect her from being fired for that speech? The answer turns out to be surprisingly complicated. Of course, the First Amendment usually has nothing to do with employment situations because the Constitution only binds government actors. If you work for a private company, you can be fired for speaking your mind, and the Constitution has nothing to say about it. But a public university is a government agency, so it is bound by the First Amendment's protection of free speech. On the other hand, the Supreme Court has recognized that when the government acts as an employer, it has a right to determine what its employees say in their official capacities, including by punishing speech that contradicts the message it wishes to send. Such speech is not protected by the First Amendment. If a postal worker tells all the mail recipients he encounters on his route that UPS and FedEx are superior to the U.S. Postal Service, the Postal Service can fire him without violating the First Amendment. But public university professors seem like they belong in a different category than postal workers. Public universities need free inquiry and free speech, academic freedom. And you really don't want states censoring the ideas that professors can share in their classrooms and publications, even as they contribute to public discourse. Some federal courts have held that there is an academic freedom exception to the government employee speech rule, but they've struggled to articulate why it exists or how it works. I argue that an academic freedom exception to government control of employee speech makes sense under Supreme Court doctrine. The court's rationale for allowing the government to control its employees' official speech is to give the government leeway to communicate certain messages. But professors are in a unique situation. They're hired specifically to contribute to the marketplace of ideas. So as long as she is also teaching the university's required curriculum, a professor who voices controversial opinions on the job is not acting as a rogue employee. The professor is in fact doing exactly what she was hired to do, and I argue her speech deserves First Amendment protection. Of course, this unique aspect of public university professors' speech does not mean that the First Amendment absolutely privileges these professors to teach or publish whatever they want to. Instead, I believe what they say in their official capacity as professors can be protected under the First Amendment by means of the long-standing First Amendment test for public employees' private capacity speech. That test asks whether the public employee's interest in speaking as citizen outweighs the government's interest in an orderly workplace. Does the professor's interest as a member of society in freely circulating an idea among college students, other academics, and the public at large outweigh the government's interest in creating an effective educational environment? The answer will depend on the circumstances. For example, the government can certainly fire a professor for loudly lecturing on the latest theory of Bigfoot's existence at a student disciplinary hearing, but not for publishing an article advocating that same theory. This balancing test is more protective of public university professors' official speech than the typical rule of absolute government control of employees' official capacity speech. In my view, it is the best way to both safeguard academic freedom and foster a vibrant, intellectually diverse society.